I'd like to welcome this bill as well, and I think it's an important point. And I think the idea that any legal aid scheme would exclude or take into account, I suppose, income that isn't really in the possession of an individual is wrong, and I think it's right that we should correct that. And I welcome the intervention of Minister Naughton in this regard, because I think it's very important that we recognise that really legal aid should be a reflection of somebody's disposable income, as it is, for example, in the context of criminal legal aid. I know this bill specifically deals with civil legal aid, but actually I think that the model that's used for criminal legal aid might be a very good model for assessing how we should be administering civil legal aid. And I agree with Senator Clifford Lee insofar as I don't think anybody within the Legal Aid Board is setting out to exclude any one individual or any category of people. They are obliged to work within the rules. And I think for a very long time, civil legal aid has been something that we have perhaps not been very proactive on in terms of putting it in place and making sure it serves the people it's supposed to serve. And reference has been made already in this discussion to many of the most dire cases of where people need civil legal aid, cases of childcare or child protection, cases of barring orders and protection orders that one spouse might take out against another, invariably a woman against an abusive husband or partner. They are the worst cases, but there is a whole wide panoply of cases that are covered by civil legal aid, including, for example, a lady I've been working with in my own area who hired a builder, for example, who absolutely destroyed the part of her house that he was working on. She needs to sue him to recover the money, to fix the mistakes that he made. And we have been trying now for the best part of a year to get an assignment of civil legal aid. It has come now. But the fact that she's waiting that long, when the clock is ticking on the statute of limitations, for example, and taking the civil action against him, it's stressful for her, and it's wrong that it should take that long. But that's a resources issue. I don't think there's somebody sitting in the Legal Aid Board saying, let's delay this as long as we can and maybe she'll go away. I don't think that's happening for a moment. The reality is it's a resources issue, and that applies to legal aid across the board. It is, in fact, I would say politically, and I don't level this charge against anyone in this chamber, politically expedient very often to criticise legal aid schemes because people see it as payment to lawyers. And Senator Clifford Lee raised this issue as well. The reality is that anybody working as under payments, under payments under a legal aid scheme, be it civil or criminal, is being paid the very lowest fees available to any lawyer anywhere in the country. And that means that a lot of people choose not to be involved in that kind of work. They choose not to do work that's paid for by the legal aid because of delays, because of low pay rates, etc. And that obviously has a knock-on effect in terms of the level of representation, the availability of representation for people who have to operate under the legal aid scheme. So that's something that must also be addressed. And I note, for example, that I received correspondence from the Bar of Ireland recently in terms of the restoration of fees for criminal barristers under their legal aid scheme. They had their fees cut, as all public servants and public workers did at the time of the financial crash now over a decade ago, but they have never been restored. So they're still working on rates that go back to the early 2000s. And that is going to discourage more and more lawyers from actually getting involved in that type of law. So I know the Minister will take into account that if we want a properly functional system in civil or criminal legal aid, we must pay lawyers at the level that makes it viable for them. And encourages particularly young people coming into the professions, be it solicitors or counsel, to get into that kind of work, to serve the very people who need to be served as lawyers. And I absolutely support what the proposers are saying here about the fundamental nature of the need for people to be represented in court by professionals who know what they're doing, who know the landscape, because it's a tremendously intimidating experience for anybody who isn't used to it to go into a courtroom, into the formality of a courtroom, however accommodating a judge might be, and to face a legal argument or a legal issue in that court. It is only right and proper that they would have the benefit of professional help, of people who understand what they're doing and know the landscape as well, because for many people it'll be their first time in a courtroom. They won't be familiar with the language, they won't be familiar with the room, where to sit, when to stand, all that kind of thing. And having the benefit of somebody who's there to fight your corner is tremendously important, and that's what the solicitors and barristers of this country are there for. It is right and proper that we as a society pay for that and put those people in place to represent the very members of our society who need that support. So what I would say is that this is an important bill. I wouldn't deny that. It seems to me, my understanding is, with the intervention of Minister Naughton, that to a large extent what this bill seeks to achieve is already in train, and I hope that will happen quickly. One thing I will say, and again I've already made comparisons between the civil and criminal legal aid systems, is that it is a matter of course in criminal legal aid, and obviously in the context of for example, the human rights obligations we have internationally, everybody is entitled to access to justice. Legal aid is a fundamental part of that. But in the case of criminal legal aid, it is a matter that is assigned by a judge. And so we circumvent the bureaucratic nature of having to go to the Legal Aid Board, and I say that without any criticism of the Legal Aid Board, but the reality is that anybody in this space, irrespective of whether they are in receipt of HAP or not, or whether the process is quick or not, they are facing a bureaucratic mountain that has to be climbed, and we need to make that a hill or even a speed bump, rather than anything that is going to in any way substantively interrupt their opportunity to get professional assistance and to put their best foot forward when it comes to the courtroom. But Gurmaga the Caherlic.